Okay, thank you. What he's saying.
Ta-da! Okay, ta-da!
The amazing race, got info. Mr Hanson and show his tendency on not being he's got these. Okay, let's see, have an essay question. But it doesn't tell us what to do. It doesn't tell us where to go, right? It's just a question. Route info. I will. You want to be at the losing end or the winning end? I want to be at the finishing end. I finish, I'm happy already. Solving.
I also follow you.
Level 4, level 5 and level 6.
Do you think we can find something there?
It's at level 9.
Sure.
Trust me. What's going on? Why are we all going on? You know that we're on.
Seriously?
Nobody there. There should be someone. Maybe you were wrong. Okay, there's no one there. Yeah, go to the end there.
Let's go.
Wait, are you guys sure it's there? No. Can. But
At the end of the day, maybe when you finish, it's all there. So then we
It's
can
a main clue anyway. We just need to find more clues to get this. Are we not listening to that?
我觉得是对了，我不知道，but you guys check out.
Please don't jump off.
你看我分嚟。I think we just go. Hi.
Let me try Layar app lah.
Yeah, we try Layar.
Layar. Okay.
Okay. See if there's anything.
Yeah.
Is there anything? Yeah, I got.
yeah, it's probably something.
Point back to see content.
It's the reason probably should
They are recording everything, so. Oh, okay. There are some things already. Where's my app? Progress.
see other groups.
Okay, it's the Ellenborough Park, Kahoot, near port. Email Miss Sophia for inquiry. But she gave us a bunch of videos. Take the notes only, Ivan. Run.
How do you take photos of this? Is there a button for photos?
Okay, and then
Or you can see that whenever people refer to easements, they are essentially incorporeal hereditaments. It's something that you have certain rights, but you can't see it. It's abstract in nature, and you can't
Cannot
use your
see.
five senses.
Wait, where is she? She's
To touch it to
Yeah.
determine if you
Yeah.
have a right.
We
So
go where
it's
she
your
is.
right. You know that you have a right on other people's land, and as such, you can continue to use it. So that's general.
She talk about right to staircase, right to park your car.
Right? And
So,
whether or not
probably
it can
the
be
staircase or the
transferred
car
to
park.
the successor in title or to the new purchaser. Which
I
just
feel
now,
like it's taken from.
there's no
Papa?
Line easements, they are express easements, and they are prescription instruments. IEP, EIP, entrepreneurship, investment and partnership.
你们有开那个 Layar 看了吗 Because when you layer the thing, right, you see this, and then but the problem is, right, there's just one. These are videos lah. These are the videos where she talks about. Yeah. But then they got 3 places here. I think we can check because just now this one, right, is where we found the second one, ma. This is where we found the second one. Maybe we can check these 2 places. This one is.
This one is
This one is. Do you know where this one is? This one. It's right by the lake. Yeah, we can check. We can check that. But then I don't know where the one on the left is.
check the car park.
I think block this car park.
Those bedrooms are. Policy. Detour. That's right.
This one is new stuff already. Last Friday, Mr. Hanson, a scientist at TU, came to a legal clinic to seek advice whether the satellite dish that he has installed at Block E can be removed by the university. He has installed a satellite dish in 2010 to access direct signal transfer from outer space. You need to download Layar application and to scan the poster on Easement already. Then need to view the recording on the characteristic on an Easement.
Easements, they are essentially incorporeal hereditaments. It's something that you have certain rights over it, but you can't see it. It's
I say, oh, why does it feel so good to be there? Getting what I want, boy, why does that make you so mad? You see, oh, why does it feel so good to be there? 'Cause if the struggle that you're looking for, oh baby,
Hi, I'm Rainy. Today we are learning the topic of Easement ourselves. It's called Amazing Race and it's very fun. So all of us are looking at the Mr. Hanson case. So Mr. Hanson had the title deed which he purchased the block D from Taylor University in 2009. So he had installed the satellite dish on block E. The reason that he gave to the university is that no other building could block the direct signal from the outer space. So there's an issue regarding whether the right to install the satellite dish may or may not consider as an easement. In order to understand and solve his issue, we have to learn about how the easement can be created. There's a second issue regarding to Mr. Hanson. In 2010, Mr. Hanson had come to the legal aid clinic and brought up an issue whether the satellite dish he had installed can be removed by the Taylor University, as he installed it due to the requirement from the Ministry of Science. How can we solve his issue? In order to solve his issue, we have to understand the characteristic of the easement and whether he has acquired an interest of right to install the satellite dish. And if he did, how can Mr. Hanson protect his easement? Firstly, I will talk about how easement can be created. Easement can be created by three ways: expressly, impliedly, or by prescription. For express creation, they can be express grant or express reservation. On the facts, Mr. Hanson does have legal title on Block D, but there is no mention of the easement being included in that deed. If it is, he will have an easement by express grant. As he was not the previous owner of Block E, he is not in a position to reserve any rights for himself, and so they cannot be an express reservation either. Another way an easement can be created is by implied grant or implied reservation. Under implied grant, an easement can be impliedly granted by necessity, by common intention, by the rule in Wilden and Burroughs and Section 62 of LPA 1925, also known as the wide-ranging provision. Implied grant by necessity is usually with regards to landlocked property, as in the case of Mahjong and Drame. However, it can exist in other situations, but only if a real necessity exists pursuant to pre-MRA engineering. Here, there is no real necessity to put the satellite dish on Block E, even though there will be no other building blocking the direct signal from the other space. The satellite could be placed on his own property, for example Block D, although the reception would not be the best, therefore an argument of necessity would fail. Next, concerning the implied grant by common intention, both parties must have agreed to it and can exist even outside a deed. On the facts, there is no mention whether he came to an agreement with Taylor University to place the satellite on Block D. If there was a prior agreement after the deed was executed, an implied grant by common intention would be possible. If not, it would not exist. Next would be the rule of Wilden and Burroughs, also known as quasi-easements. For an easement to be exist under these, three conditions must be fulfilled, being that the land must be 1. Undivided plot prior to the transfer. It must be for the benefit of the dominant plot and must be continuous and apparent. As Mr. Hanson was never the owner of the university plot of lands, the first condition for it fails already. So, looking at the section 22 of the LPA 1925 come into play when the intention of the party were not expressed and concern the passing on a right and miscellaneous items together with the conveyance of land. There is no express intention for the easements to erect the satellite, although the conveyance of Block D would also convey with the land or privilege easement rights pursuant to section 62 subsection 1. There's no mention that this easement existed prior to the conveyance and so would not magically arise after conveyance either. There's also no mention of satellites anywhere in the section, so an easement cannot exist by implied grant pursuant to this section. The next easement to be considered is an easement by prescription. There are three ways to establish prescriptive easement. Firstly, this easement can be created under common law. This requires that the prescription is enjoyed without the interruption since time immemorial, which is immemorial from 1189 at the statute with the Westminster 1265. The second method is by the doctrine of modern grant, lost modern grant. From Tedley Minerals and Norman case, there must be 20 years of the continual use. The third option is by the Prescription Act 1832, in which 20 years must be enjoyed without the interruption for the short period and 40 years as the long period. The use of land must be in fee simple only. There must be a deed and registration. The use of the land must be as of right, and in the case of in Solomon and Ministry and Winster held that The use must be without secrecy, without force, and without permission. The use also must be without permission. This is held in Hill and Rosner. On the fact of the case, Mr. Hanson's satellite dish cannot be made under the three methods in the first place, as there must be at least 20 years without interruption by the doctrine of lost modern ground. Based on the fact of the case, he has enjoyed the easement since 2010. As the case was first brought up last Friday, only 7 years had passed instead of 20. Therefore, it is not a prescriptive easement. In conclusion, there cannot be an easement by prescription. There may be easement by express grant if the easement is included in the deed. There may be easement by implied grant by common intention if the party later agreed. There may be easement by implied grant pursuant to Section 62 LPA 1925 if the previous owner enjoined the same right. If an easement does exist, there are certain ways to protect them. In order for Mr. Hanson to protect his easement, he must first determine if the easement is equitable or legal. If in an unregistered land, the easement must be written in deed pursuant to Section 52 LPA 1925. In a registered land, the easement must be registered under the LRA 2002. If the right is an equitable right, Mr. Hanson will need to register the land under the Class D subsection 3 for the charge to provide an actual notice to the world. Thank you.